So, for our last set of treats, we are looking at European harmonisation of IP, and we have three of the top scholars from continental Europe. Starting with Pascal of Kamina. Over to you, Pascal.
Thank you very much. First, I'd like to thank the organizers of this conference. I'm very honored to be here with you for this tribute to Bill Cornish, who was my PhD supervisor. I think all has been said this morning and this afternoon about Bill. He was an extraordinary man who changed the lives of many of us, and not just professionally or academically. So thank you very much, Lionel, for this invitation. I was given a topic on the codification of intellectual property in France, this little island of intellectual property. Well, actually, it is an island of intellectual property, especially in relation to, maybe in relation to author's right, a fortified island of intellectual property. This is clearly a topical subject because last July we celebrated the 30th anniversary of codification of intellectual property in France. So the code was adopted in July 1992. I will insist on two aspects. First, the process of codification of IP in France, its difficulties and its limitations. There are limitations in this exercise. And the impact of that codification, the impact that codification has had on the perception of intellectual property as an object of study. But before talking about the IP code, I should say a word of introduction on codification itself. As you know, codification is an ancient tradition in France, Napoleon. It is certainly part of our legal culture, and it is an essential part of the public policy in favor of access to law and justice. And in order to achieve this objective, the codification process in France has been highly institutionalized and systematized. And it was also accelerated over the last 30 years, starting with the IP code. And I should say it has been quite successful. At present, there are 70 codes in force. I checked, the number is impressive and surprising even to me, covering more than 60% of legislative text and nearly 40% of regulatory texts. These are numbers from the Administrative Commission on Codification. I should point out that these numbers refer to internal law, 60% of internal law. As we do not codify in our codes in France, we do not codify EU or international law. I will get back on that later. I should say that this love or this obsession for codification is not shared by all continental countries. Many civil law systems have a much more limited number of codes, sometimes 4, sometimes 10, sometimes a bit more. However, there are a few other intellectual property codes within the European Union. I should mention the Portuguese Code of Copyright of 1985, which was followed by a Code of Industrial Property in 1995, so 2 codes in Portugal. There's an Italian Industrial Property Code of 2005, which does not include author's rights. Interesting code. It has a general part with general principles, and it includes also trade secrets and domain names within the code. And I should also, of course, mention the Belgium Code of Economic Law of 2013, which has a much broader scope and which includes all intellectual property rights within one book. These are interesting codes, very different from the French code, and I'm sure there's much to be learned from their study. But back to the French code. There have been 3 waves of codification over the last 2 centuries in France, as you can see on the slide. The IP code inaugurates the 3rd wave, which is called the revival of codification, which started from 1989. with the creation of a permanent administrative commission in charge of codification, la Commission supérieure de codification, which comprises 12 members and which is presided over by the Prime Minister. Very prestigious commission, hence supérieur in the title. This commission is in charge of scheduling the codification work and of setting the methodology for drawing up the codes. It also coordinates the works of the ministerial services in charge of working on the draft codes before they are presented and voted in Parliament. And they become law once they are voted in Parliament, and all the codified acts are, at the same time, are abrogated. As mentioned, the Intellectual Property Code was the first code to have emerged from this wave of codification. But I must say it was not adopted first because it was the most important. In fact, there was no planification order for the adoption of the new codes. The IP code was adopted first because it was the easiest to pass through Parliament. There was no real discussion and no idea of reforming the rules on intellectual property. However, the work which was carried out for the IP code has led to the adoption of many principles, which are principles of codification, which have been applied to the other codes. So this code is also important in this respect. The function of modern codification in France is the simplification of the law, as opposed to its systematization and reform. So the modern codes are very different from the Napoleonic code in this respect. As a result, the principle which was adopted since 1948 for codification is what we call codification à droit constant, which means codification without affecting existing legislation. The main advantage of this form of codification is that it makes it possible to move more quickly toward the adoption of a code by separating the work of codification from reform. It's mainly a pragmatic approach. But I must insist on the fact that codification à droit constant involves much more than the mere inventory and compilation of scattered text. As you can see on the slide, it implies a lot of work on the text, delicate choice to be made as to the scope of the code, and you also have a lot of technical questions to solve when setting up a new code. So that's a very complex and time and resource-consuming task, and that might explain why we have not been very good or very successful in exporting our intellectual property code to other continental jurisdictions. Let us now return to the IP code. First, a word about the background to the adoption of the code. Before 1992, there was no horizontal legislation applicable to all intellectual property in France. And there was no reference in the existing legislation to the expression intellectual property. The expression intellectual property was used in legal literature, but other expressions were also used, and they were somewhat interchangeable. We use the expression droit intellectuel for those who intellectual rights, for those who want to avoid using the term property, or propriété incorporelle, intangible properties. And these expressions were used. And in addition, in France, the academic community, which is historically strongly divided between copyright specialists, authors' rights specialists, we'll use the term copyright. Nobody's French in the audience, so I can use the term copyright without risk. Which was divided between copyright specialists on the one hand and industrial property specialists on the other hand, was rather hostile or at best uninterested in any kind of horizontal study of intellectual property. There was at that time, not a single intellectual property book. Not a textbook. There were textbooks on intellectual property up to the beginning of the 19th century, and then they disappeared from the doctrinal landscape. even doctoral theses in our field were either on droit d'auteur or on industrial property, which were considered as two distinct subjects, one belonging to civil law, the other one belonging to commercial law. So why did we end with an IP code and not a copyright code or an industrial property code like in Portugal? Well, the Commission, the Codification Commission, did not elaborate on this point, but it appears that the main argument lies in the size of the proposed code. Droit d'auteur alone, especially at that time, 1992, very few directives, one I think, could, on author's right, droit d'auteur alone could not justify a self-standing code. So the choice was made to include industrial property as well, also for proximity reasons. But there's no overall design in this matter. In this process, more than 22 pre-existing acts have been codified and then abrogated. Quickly on the structure and content of the IP code, the code does not contain a definition of intellectual property. There is still no legal definition of the term in internal law. There are doctrinal proposals, but no legal definition. And the code does not contain an introductory or general part, which is surprising for a French code because the grouping at the beginning of the code of the general principle governing the codified matter is one of the recommended codification methods. But again, at the time of the adoption of the code, these general principles were not really identified nor consecrated, and the mere regrouping of provision on, say, procedures or sanctions, which would have been possible, would have implied substantial modifications which were far beyond the mandate of the Commission. The code is divided into two main parts, which consecrate the distinction between literary and artistic property on the one hand and industrial property on the other hand. That's classical. But droit d'auteur comes first, intellectual first, and then commerce. Much to the disappointment of patent specialists at that time. There was some kind of fight. The part on industrial property includes registered design first, then patents, then semiconductors, plant varieties, trademarks, but geographical indications are codified in the consumer code. The consumer code was codified after the IP code, but the law on geographical indication was not codified in the intellectual property code, mainly for political reasons, but it's a long story. And that's it for the code. For trade secrets, at the time of the adoption of the code, trade secrets were protected exclusively under the general principle of civil liability included in the civil code. So there was actually nothing to codify in this respect. Same thing for unregistered distinctive sign. They were protected under the law of unfair competition, which belongs to the civil code because it's an application of the general principle of civil liability. With the IP code, the Commission inaugurated a new form of numbering, which was adopted in subsequent codes, which is supposed to make it possible to identify the place of each article in the code. So I refer you to the example on the slide. It took a while to IP specialists to get used to it, and it is not entirely satisfactory. And this form of numbering is not adapted to amendments. Now we have numbers, very complex numbers in our code, such as L122-5-1-2. It doesn't work very well. Since codification is not to affect existing legislation, very few substantive changes have been made in the process of codification, including, and that's interesting, at parliamentary stage. I mean, the parliament really played by the rules of the game of codification à droit constant and didn't and express of kind of self-restraint to accelerate the adoption of the code. And mostly the internal structure of the codified acts was preserved, which leads to discrepancies in the way the different monopolies are presented. So there's no harmonization in the presentation of the different monopolies. Subject matter, exclusive rights, exception, initial ownership, contracts. No, we don't have that. So we sometimes we have to deal with a presentation which is a bit different. Of course, EU law has had an impact on the language and to a lesser extent on the internal structure of certain parts of the code, especially in relation to authors' rights. But I will not elaborate on that, and I think we are all in the same boat in this respect when it comes to implementing European legislation. So, what is the outcome of codification from a technical point of view? The bilan in French. As it is, the code is certainly practical. And the private editions of the code, which were published after the code, which include case law and additional missing text, are certainly very useful for practitioners, very useful for students. However, within the scope of codification, the Codification Commission's stated objective of comprehensiveness has shown some limitation. A few examples of that. First, a few, is that slide 5 or 6? Let me just check. Yeah, okay. Yeah, I have to buy some new glasses, some progressive lenses, but I'm too young for that. First, a few provisions on IP are not included in the IP code. A few provisions are included in other codes. This is the case for geographical indication, which are in the consumer code. There are some exceptions to copyright, which are included in the Code du Patrimoine, which would be the Code of National Heritage, and in relation to distinctive signs, there are also exceptions in various codes, including the health code, preventing the registration of certain categories of signs. But that's not the most important limitation. What is probably most important is that the fact that the Commission decided not to codify the transitional or temporary provisions, and the difficulty is that this principle, because that's a principle of codification, is not applied uniformly. So some transitional rules are in the code, and others are not. And when they're excluded from the code, then you have to look for them in the relevant legislation, but there's no indication within the code there's no reference in the code as to their existence or location. So it can be quite difficult. Also, and that's an important point, the code does not contain references to international texts, which has been and is still criticized. The Codification Commission had originally planned to incorporate the relevant text of international law into the code. And the idea was even put forward to create an annex including the EU regulation and the list of applicable directives. However, the idea was abandoned. The legal explanation put forward by the French administration is that it is up to the EU authorities to codify their own standards, which is not entirely convincing. This absence of codification, of course, is problematic, especially when France has not formally transposed certain provisions, or for certain provisions that may be or become contrary to EU law, especially private international law rules. Last limitation, the regulatory part, which was of the code has a legislative part and a regulatory part. The regulatory part, which was adopted in 1995, does not include the rules emanating from the independent administrative authorities, Again, the reason given is that this text cannot be codified by the government, otherwise the independence of these bodies will be undermined and the different levels of regulation will be confused. But the code does not contain either the text of the collective or professional agreements to which the law refers for the determination of certain rules, especially in the field of copyrights. And lower ministerial decrees, what we call arrêté in France, which is the lowest level of a decree, are not codified in the IP code as well. So this is quite problematic, especially in the field of copyright, where the regime of some copyright contracts is largely defined by reference to professional agreement or code of practice to be adopted or adopted. And the Single Market Directive certainly reinforces this difficulty because it makes a lot of reference, it authorizes and makes a lot of reference to professional agreement. Now I can come maybe to the most important question in the context of this conference. What have been the effects of the adoption of the code on the perception of intellectual property as an object of study? The code, the IP code, certainly had an influence in this respect. It represents a departure from the previous approach of IP, if only by its title. First, because it uses the term property. That does not resolve in itself the controversy on the characterization of IP as property, but it certainly gives strong argument, it gave strong argument in favor of such an assimilation, which in the civil law system, and especially in France, has many, many technical consequences. The characterization of property has technical consequences. Second, because the title uses the singular, it's the code of intellectual property, not of intellectual properties, and that, of course, emphasizes the unity of the matter. So even if there was no overall design in this respect, the IP code certainly favored and justified horizontal approaches to intellectual property, which was somewhat validated at the international level by TRIPS and later by at EU level by the Enforcement Directive. Just a few illustrations of this evolution. The first doctoral thesis on the question, the first doctoral thesis on a transversal and horizontal issue affecting all intellectual property appeared in the late 1990s, and this is now commonplace to have theses on things like infringement or even general theory of intellectual property. So it's commonplace now. The first review on intellectual property, there was no book on intellectual property, but there was no review as well, no legal review on intellectual property. The first review of the kind was published in 2001. Few years later, in the landmark decision of 2006, the French Constitutional Council confirmed that the constitutional guarantee of property as a human right applies as well to intellectual property rights, still without giving a definition of intellectual property. The first French intellectual property textbook is that of my colleague Nicolas Banctin. It was published in 2010. I know he read this book. It is an interesting book as it is the first one to contain a general part on intellectual property, like Bill's book. But for Nicolas, it's at the end, which is a bit strange, but it's the way he wrote his book. This idea was followed by several textbooks on intellectual property. So now we have textbooks on intellectual property with general parts, with the content of which, of course, may vary. But we have such books which didn't exist before the IP code. And we, as I mentioned, we now have a growing literature of something which didn't even exist. The idea was not even raised before the IP code. A legal literature on the general theory of intellectual property. So we don't have a textbook yet on the general theory of intellectual property, but this will probably come at some point we will need a new Bill Cornish, a German Bill Cornish would be perfect for that. And also there are also signs of this evolution towards transversal horizontal approach to intellectual property. You can find also signs of that in the case law. I don't have the time to elaborate on that, but now we have cases which set clearly principles that for the courts are applicable to all intellectual property. This vision is also reflected now in some part of the code, of the intellectual property code. For example, most procedures and sanctions have been harmonized before between the various intellectual property rights, which was not the case before, even if copyright retains some peculiarities. And the code itself has slightly evolved in that direction. We have, since 2010, we introduced in a new form of protection of geographical indications, and these were included in the IP code, not in the consumer code. And also the legislator reintroduced all the provisions on infringement of geographical indication in the IP code. So some provisions are in the IP code, some provisions are also in the consumer code. The French legislator now since 2014, use the term infringement contrefaçon to designate the infringement of geographical indication, which is a term, contrefaçon, a term which is restricted to intellectual property, and a term that the legislator before carefully avoided to apply to geographical indication. There's a limit to that evolution of the code. The scope of the code, as I described it, was not extended further. For example, the specific protection for trade secrets, which is derived from the directive of 2016, has been integrated in the commercial code, which is a strange solution since the protection is not limited to traders within the meaning of the commercial code. Also, there are sui generis protections outside of the code, very close to a neighboring right, which could have been inserted in the code, which have been modified, amended, but they're still out of the code. One example of that is the sui generis protection of organizers of sporting events, which is defined in the code of sport. But this is really quasi intellectual property. But the term infringement is not used. In the definition which are proposed by legal authors of intellectual property in France, many definitions insist on remedies and on these aspects, sanctions. And what makes intellectual property specific is the action en contrefaçon, closely. So the right is defined by the way it is enforced. So that's an interesting point of view. As a conclusion, what are the perspectives of the codification of IP in France? As I said, last year we celebrated the 30th anniversary of the codification. At this occasion, there were conferences organized. Many proposals emerged from these debates, all of which focused on the ways to improve the code. There are several ideas are making their ways. First, the idea of a preamble, a general part in the code, which could cover things like private international law principle, procedural rules, general principle on the articulation or accumulation between IP rights, very delicate problems, and articulation of IP with unfair competition, which is an ongoing problem under French law. There seems also to be a consensus on the broadening of the scope of the code, in particular through the inclusion of similar protections, such as trade secrets or the protection of non-registered distinctive signs. These proposals are very interesting, but I should say that for the moment, this reform is absolutely not on the agenda of the government, and it remains to be seen whether there will be support for it outside the academic community. But maybe most importantly, during these conferences, concern has been expressed and maybe that's the most important question, as to whether working on improving the code or even codification at national level of intellectual property itself still makes sense in the current context of European harmonization. But that's beyond my subject and beyond my 20 minutes. Thank you very much.
Thank you. And now we move from Lyon to Munich. And first of our pair from Munich, we have Annette from Max.
Yeah, thank you so much. And it was really interesting. We did have an academic project in Germany not too long ago that was about, well, whether one should, or it was actually a proposal to codify intellectual property in one law book, actually. It didn't really fly. One might discuss the reasons why. But yeah, dear friends and colleagues, I'm very, very happy to be here with you. So thanks a lot, Lionel and Henning, for inviting me. I have to admit that at first I wasn't so happy with the title that I received from it was about, similar to David, it was about constitutionalization, and I of course realized that this is an important aspect of European harmonization or Europeanization of IP law, but well, it's not one of my favorite subjects, and also I didn't really know how to connect it with scholarship, because I didn't remember having seen or heard a bill actually talking about constitutionalization or fundamental rights. I do remember that when the Human Rights Act was passed in the UK that made the European Convention on Human Rights applicable, he did say that this will be a big topic also regarding the interface with IP rights, but he, I think, didn't really participate very actively in the debate. But of course, Bill was very keenly aware of the tensions between the exclusivity paradigm or property logic on the one hand and countervailing interests such as freedom of speech and oh, I'm not. I didn't. My fault. I did not put it on. So it should be better now, right? Mm-hmm. Good. Yeah, thank you. Thank you. I then moved it, or we moved the title to property, and I'm very happy about that. And when I was looking through material in order to make myself more familiar again with Bill's thought, I came across this one, which is a book that contains the written versions of contributions that were made at an event that was celebrating the moving of the Max Planck Institute from the old cozy premises that David was referring to the current quarters near the Hofgarten in Munich, which is much more modern but less comfortable. And the book is in German, and Bill's contribution is in English, so I thought it's maybe not so well known to all of you, so I can actually quote from this one, so I can let Bill speak and I just interject here and there to connect it with the background and also with current times. And after having been listening to Francis Gary this morning, I cannot resist telling the one little story. So I was one of a group of three that were organizing this conference. One was Alexander Peukert and Thomas Dreyer, and the director at that time of the Max Planck Institute, Gerhard Schricker, said that he really didn't care so much about, well, what we had on the program, as long as the word innovation was in the title. So that's true. So we called the symposium and also the book Geistiges Eigentum im Dienst der Innovation, Intellectual Property in the Service of Innovation. And we gave Bill the keynote speech, and he was talking about the expansionist tendencies in intellectual property, which was probably not exactly what was expected, but so let's go back for a second to the situation we had then. Of course, the 1990s
were an age of, well, political development, very, this fall of the Iron Curtain and coming up of new nations. And in regards of intellectual property, much had been happening. It was really a powerhouse of development, both on the international level and the European level. So we had TRIPS, we had the WIPO treaties, we had more international treaties also by WIPO. And of course, the European Commission had set out in earnest on its course to harmonizing and unifying EU law. The trademark project was concluded, design legislation, both directive and the regulation was on its way. We had other regulations, geographical indications, supplementary protection certificates, plant varieties. We had the biotech directive in patent law. We also the supplementary protection certificates, and then, of course, last but not least, also the developments in copyright, where we had the piecemeal progress in harmonization by the directives. And where all that happened, the course was clearly marked in the direction of expanding the rights, having stronger rights. So that was Bill's, the situation that Bill was talking about. And he first analyzed the reasons for that. So he said that, of course, there are these technological developments, the digitalization, but also there's very heavy lobbying. And he then said, in today's conditions, and here I quote, in today's conditions, it is hard to distinguish the truly deserving from the implacably demanding. And he offers a warning. IPRs stand as a qualification upon the ordinary processes of competition, which include a freedom to use and adapt the ideas of others in a process of constant and inevitable interchange. If IPRs were not limited and conditioned, we would offer too easy a prospect of belligerent operators to claim monopolies which are quite beyond any special contribution which they may have made to the process of technological, cultural, or economic development. All except wildly extreme theorists of property rights accept this premise. Of course, he notes then that even if we don't go to these extremes, there is still a need to talk about the exact measurement of the conditions and limitations that we have. So he says, quote, we are engaged in an argument about how IP laws can be crafted so that on the one hand, value can be secured in intellectual labor, while on the other hand, enough and as good, to use John Locke's counterweight, remains for others to take advantage of innovations and creative works and to promote their own products and services by equivalent means which they have developed for themselves. So this is his premise. And he then turns to the process of harmonization and says, our experience with the Commission and WIPO and the negotiations for TRIPS is that there is danger in too rapid a response to claims for new protection before those with countervailing interests have had time to weigh up the demands and present contrary arguments. It is highly desirable that IP legislation should provide within its own framework a complete balance of interests. The experience that Bill Cornish refers to, well, doesn't have to be commented in so far as TRIPS is concerned, and maybe also the WIPO treaties and others. So I leave that because we are interested in the European development. And also there, I don't think that Bill, and I know from remembering talks with him, that he was critical of all the developments. He was definitely critical of some tendencies. He was critical about the expansion of trademark rights to new, in scope and also new subject matter. So he would definitely have preferred if trademarks would have remained confined to the origin function. He was also critical about the threshold for design protection being too low. He was definitely critical about database protection, and he was also anticipating a lot of problems with the, at that time, pending proposals for patenting software-generated patents. And in that regard, he was also very skeptical about the potential of the dam erected by the EPC by requiring a technical effect of computer-generated inventions, because and that led him to the sarcastical question. And again, I want to quote him. Yes, he said, well, quote, "Are we to end with patents for baking novel cakes because putting the cake in an oven counts as technical effects," unquote. Now, fast forward to where we are now. It's, as we see with regard to this proposed directive on software patenting, it's not all of this has become true. And we can really say that now, both on the international level and also on the European level, we have now a much stronger focus on limitations and exceptions. I don't have to tell you everything about that. You're all aware of these things. We even had quite spectacular failures. Well, on the international level, it was ACTA, the proposed anti-counterfeiting trade agreement, and on the European level, we can point to the software patenting directive, where we had an uprise of people marching the streets, both with regard to ACTA and also software patenting. So critical remarks, critical observations by academia and by civil societies, they have really borne some fruit. But of course, the exclusivity paradigm of intellectual property still stands firm, and in spite of the failure of ACTA, we have seen in the form of the Intellectual Property Enforcement Directive that the arsenal of sanctions has really been enhanced by European legislation. Now, going back to this to the speech of Bill Cornish, Bill also had another point that he very succinctly made. He realized that by expanding the scope of protection of intellectual property rights on the one hand and lowering the threshold in certain areas like design rights, and also he was thinking at that time about another pending proposal which did not come to fruition, the proposal on utility model protection. It was also a proposal for harmonization in that regard with a very, very, very low threshold. So he was realizing that this may, of course, increase the potential for overlaps. And he said that, okay, all these IP rights are, of course, taken together. They are to be looked at together, because that was, of course, the achievement of this book that we are also talking about here. In spite of all these commonalities, these fields should not become merged to the point of indistinguishability. And here I quote again: "The three models of IPR, patents, copyright, and trademarks, may belong to a single family of rights, but each model is very distinctive. As lobbyists strive to stretch each model to cover their particular needs, it is vital to keep in mind the differences between the models in their objectives as much as in their detailed concepts. Each has been shaped by long measures of historical experience, which may include tests of what amounts to overprotection. We do well if we bear this constantly in mind, rather than falling in with expansionist claims which have as their rhetoric a set of assertions, rarely quantified, that the world has changed and therefore needs new, more absolute intellectual property." And that brings us to the notion of property that we want to address through the lenses of what is expressed in Bill Cornish's article. And here are quotes again. "Today's expansion of IPRs has stimulated a rush in the characterization of the rights as property. The debates occur at a level where theorists speaking from a philosophical, jurisprudential, economic, sociological, scientific, or cultural perspective can engage with those who have personal, practical, managerial, or investment interests in the subject. The nature of property, both intangibles and intangibles, is a basic issue in a world which is refurbishing free market economies to fit a global interaction. The debates over IPRs attract particular attention because their range is increasing and because they are becoming less and less qualified by conditions. The characterization as property underscores this evolution. A property right implies an exclusivity that is as little fettered as possible in scope. It can be enforced just as it can be transferred without preconditions or the need for complicated evidence, such as one finds with equitable concepts of unfair competition. Modern property law, as it applies to land and movable things, fulfills the underlying goals of Smithian individualists who see in the ability to retain and exploit a thing or to dispose of it at will the optimal condition for realizing the social value of any asset. By analogy, so it is argued, intellectual property, and as large a measure as is compatible with other social values, deserves to be allocated to an owner, preferably one single owner. The owner of intellectual property is accordingly empowered to realize the economic potential of the subject matter, armed with the ability to prevent other versions of the same product or service, or one very similar, to be marketed in competition. So what to do about that? Here's Bill's reply. Policymakers and academics must encourage studies by applied economists and economic historians, from which estimates of need can be more adequately sustained. It should not, for instance, only be in cases of intractable confrontation, such as the conflict over design rights and spare parts, which was rampant at in that time, that the European Commission conducts surveys of the consequences to industry of particular solutions. It may be difficult to contract existing intellectual property rights, but most countries with substantial experience of IPRs will have seen some fluctuation of protection downwards as well as upwards. Unquote. Here, I must politely disagree with Bill. During the years that I have observed developments in intellectual property, and that's an area that I, at my age, may also call historic, it has never been so that existing rights, once labeled as intellectual property, were repealed. I gladly stand to be corrected, but I doubt that there is any counter evidence. And concerning the need of interdisciplinary research, not least supported by economists, that's definitely right. And it's increasingly observed also in practice, both in academia and in politics. The European Commission does conduct economic studies on a regular basis in the preparation as well as the monitoring of legislation. But speaking for myself, I'm a bit disillusioned about the degree of certainty and reliability that such studies are able to provide. That is, of course, particularly true when it comes to predicting effects of taking certain legislative measures as opposed to abstaining from them. And as rich as instructive historical studies may be, transposing experiences once made into a contemporary environment may not always provide the right cues. On the other hand, such cautionary tales do not discredit the call for an interdisciplinary empirical approach expressed by Bill Cornish. If I have some more minutes, I would like to turn to copyright, because that was also addressed in Bill's talk. And I have to say that was at the time when the InfoSec directive was pending. And of course, all of this was when the internet had become, the mass use of internet was in its still rather early days. Bill starts out by saying that as a matter of principle, incorporating copyright into the digital age was no big problem because, quote, in industrial conditions, we have been willing to treat non-physical uses of authored works as an aspect of copyright in them. It has involved no fundamental alignment of thought to establish copyright liability for making works available through the internet. Indeed, it has provided trickier to define the extent of those secondary, to define the extent of liability of those secondary facilitators who make up the distribution chain across the net, then determine the responsibilities of content providers. Here, we know that is indeed the case. And he also sees the broader ramifications of the digital age. Derivation of one work from another has become immensely more pervasive with the advent of the latest information technology. Digital format allows the deconstruction of works and performances to an extraordinary degree. Each instrumental line of an orchestral recording, for instance, can be detached, and innumerable deconstructions may be made according to taste. Politicians and pop stars can be flatteringly depicted by their spin doctors and debunked by newspapers. It's hazardous to predict how the traditional tools of copyright thought will work in this new environment. So here we see a foreboding of not only using and putting together fractions of works, but also manipulation of content, including fake news and deep fakes. Sure, this goes well beyond the realms of copyright proper, but copyright thought, as Bill calls it, namely the claim for integrity of protected content once it has been released to the public, does have a role to play, just as notions of what on the continent would be called personality rights or public rights concerns. But let's continue with Bill's thoughts. Legislation, quote, legislation may eventually provide some guidance on what should happen, but the notion of infringement and the limits set to it by defenses such as private use and fair dealing have always depended very largely upon the moral attitudes of courts. Moral attitudes of courts, and that will equally be true in the digital environment. What is important at this early stage is that legislation should not unduly hamper courts in the process of determining what necessary adjustments are needed. The attempt in the European Union's proposed Information Society Directive to place exceptions and limitations into strictly laced confines of a common European copyright law must accordingly be looked at with acute critical attention. In particular, the insistence that national lawmakers be deprived of any independent power to decide upon the scope of exceptions seems destined to lead to unpredictable and confusing results as unforeseen tensions arise. Spot on. This is definitely, has been definitely true. It clearly disavows not only the timid, strictly limited way of lawmaking in the EU, but also the Commission's clinging to the mantra of a high level of protection, and also the Court of Justice's constant but wrong mantra that limitations must be applied narrowly. No, limitations don't have to be applied narrowly. They must be applied in accordance with their purpose. It is true, of course, again, fast forward. The Court of Justice has come round to acknowledge the obvious, but they needed time, and they needed fundamental rights as their vehicle. And here we come to connecting this with constitutionalization and fundamental rights. It really seems to be so. I mean, the Court of Justice did make reference to fundamental rights before, but after the Charter came into existence in the EU, and there was the prospect of Article 17, second paragraph, leading towards an unlimited notion of intellectual property being an unlimited and unfettered, they erected the barriers, and they said, no, this is not something which is inviolable, it is something that needs to be balanced. And then they started using this balancing tool based on fundamental rights in a nearly inflationary manner in copyright. So we are already at that point. But Bill's warnings and his plea for openness still would have been the better way from the beginning. We might have spared the fruitless and agitated discussions about hyperlinking if there had been an opening of copyright before. And also the back and forth with regard to including a tiny fraction of pre-recorded music in a sampler might have been unnecessary. And also some other discussions that we see right now. I don't want to go into detail, but regarding the implementation in Germany of Article 17 of the Digital Single Market Directive, which relies to some extent on a notion of a transformative use it may have been, or may be easier be dealt with if there had been this opening that bill already was calling for back in 1999. So Bill's advice is definitely a valid one, but who would have doubted that anyway? Thank you very much.
Thank you, Annette. And last but not least, by any means, Ansgar Ohly from LMU.
Okay, so, ladies and gentlemen, I'm the last one between you and your well-deserved Friday evening. Nevertheless, thank you very much to Lionel, to Henning, for your kind invitation. I must start my presentation with two apologies. The first apology is that I also took the liberty of modifying my topic a little bit. When you compare this one to the program, you will see that I skipped the words databases, the press publisher's right, and data. I will refer to them, but only very briefly. Otherwise, our day, our beautiful conference would have ended on a very, very sad note, and I didn't want that. The second apology that I owe to you is I have two introductory slides, some homage to Bill Cornish, and some of you have seen these slides before. I have used them before. I apologize to all of you who have already seen them, but I thought they were quite appropriate for this occasion, and I promise I will never use them again. So, when I first came to Cambridge in 1991 to start my LLM, I had to choose 4 subjects, 4 options for this LLM, and I knew 3 of them. They largely corresponded to the subjects that had been my favorite subjects in my undergraduate years in Germany. But the 4th one was still missing. So I didn't really know what to choose as the fourth subject, and then one of my colleagues, actually the lady over here in the 3rd row, suggested that I might join her to attend the intellectual property law class. She said it's a very interesting topic, it's international, and the lecturer is very inspirational. He's very inspiring. And so I accompanied her to the intellectual property class. The subject was very interesting, it was very international, and the lecturer was extremely inspiring. And so I owe a lot to Bill Cornish. He was my first and probably my most important teacher of intellectual property law. He encouraged me when later I decided to do my doctorate in that area, gave me a lot of advice, brought me in touch with the Max Planck Institute in Munich, and now tort lawyers and criminal lawyers often use the but-for test to determine causation, and I can say, but for Bill Cornish, I wouldn't be standing here. I probably wouldn't have gone into intellectual property law, so I really owe him a lot. And by the way, while I was studying intellectual property law here with the 2nd edition of Bill's textbook, I called one of my friends at home and asked him to buy an intellectual property textbook on German IP law for me, because I had never heard German IP law in my undergraduate years. And he said, that doesn't exist. So he actually bought an industrial property textbook and a copyright law textbook in Germany for me and sent them on to Cambridge. Okay, so the topic that I've been given is the expansion of intellectual property rights in EU law. And when we determine expansion, we need a point of reference. Expansion from when to when, or expansion from where to where. And I'll use the point of reference that many other speakers today have also used, namely the 1st edition of the textbook. And my 2nd point of reference will be the current edition of the textbook. So what did the intellectual property world look like in 1981? Well, it looked a little bit like this. Now, the colors here are not a political statement in favor of diversity, which I'd also be extremely happy to give, but they basically symbolize the fact that European harmonization hadn't reached those areas back then. So the picture was a very colorful, diverse picture. Intellectual property regimes in the member states differed very much from one another. There's one difference here. There is one circle with a larger amount of blue compared to the other ones, and that's patent law, because of course the European Patent Convention was already there in 1981. We're celebrating its 50th anniversary this year, and while the European Patent Convention is of course not an instrument of EU law, and it didn't force the member states to harmonize their patent laws, it had that practical effect. It led to a large degree of harmonization. When we compare, for instance, the Patents Act of 1977 with the German Patents Act of 1981, we see that. Now, how does that compare to 2019? Well, Francis Gurry once used the picture of a Cambrian explosion in patent law when he looked at international developments that went on in patent law. And here I'm tempted to use the image of the Big Bang. Only that Big Bang is not quite accurate, because the distance between the intellectual property rights has not become bigger, but the planets themselves have become bigger. Actually, the more accurate picture might be this one, because there's a lot of overlap, and if we factor intellectual property overlaps into our picture, it might look like this. But let's keep things simple, and let's leave overlaps out of the equation. So this is basically what the story looks like: much more blue, much more harmonization, and different degrees of expansion. And let me look at these areas one by one for a moment, and let us look at expansion in three respects, namely subject matter expansion, scope expansion, term extension. And we could also distinguish between expansion that is legislative expansion, that is changing the law by parliaments, and judicial expansion, that is expansion carried out by the courts, in particular by the European Court of Justice. So if we start by looking at patent law, we do have subject matter expansion in the areas of biotechnology, which is one of the few areas affected by an actual EU law instrument in patent law. We have computer programs, largely by means of the case law of the decisions of the European Patent Office. Scope expansion, now I put a question mark here. We've seen a very interesting development in patent law, namely a harmonization by mutual learning, as you might call it. European judges, European patent judges, have the tendency of treating the judgments from other EPC countries with great respect, and there has been a degree of mutual influencing, and probably the doctrine of equivalence is the prime example, where the English courts came first with their three Catnic questions. The German courts reacted by picking up these three questions and coming up with three rather similar questions, and then again the English courts reacting by formally adopting a doctrine of equivalence. Hard to say whether this led to a scope expansion. I leave it to the British patent lawyers to decide whether there has been a scope expansion in British law. In German law, it's rather the other way around. The old doctrine of equivalence that we used to have in German law was broader than the one which we have now. Term extension to a limited degree by means of SPCs, of course. And finally, in terms of enforcement, of course, there is now the UPC, which will start in June, unfortunately, with the UK on board. And whether that will lead to more intensive enforcement or to a more nuanced and more balanced enforcement is something that remains to be seen. Now, my blue circle here is not as big as other blue circles on this slide, because I would argue that the expansion of patent law has been a rather moderate one. Of course, in the area of biotechnology and also in the area of computer programs, we can discuss a lot whether protection has gone too far, also compared to other jurisdictions around the world. But in a way, it is, of course, natural that patent law would extend to new areas of technology. Patent law wouldn't exclude them, and perhaps even rightly so. So probably here, I would say, expansion has still been moderate, which is very different from my next area, namely copyright law, where the blue circle is, of course, much bigger, and where our three areas, namely subject matter expansion, scope expansion, term extension, there's a lot to be said here. So first of all, subject matter. The first expansion, legislative expansion to computer programs and to databases, the first step. Then a couple of judicial expansions carried out by the European Court of Justice. First of all, now this one only in comparison to British law, not in comparison to continental European law, the abolition of the closed catalogue of works, of which the European Court of Justice probably wasn't even aware, because the European Court of Justice just ignored this closed catalogue, but reasoned without it. So if really the Court of Justice abolished the closed catalogue, as arguably it did, that would mean an expansion compared to Old English law. Works of applied art. As you know, most or many European jurisdictions, not France, but many other European jurisdictions, tried to find some sort of borderline between copyright law and design law. Most of them allowed a limited type of overlap. Old British law, an overlap for 25 years, and then a restriction of industrial work, a term restriction to 25 years. Former German law, which required a much higher threshold of protection for works of applied art, thereby leaving everyday designs, usual designs, out of copyright protection. Italian law with a separability doctrine very much comparable to the one that is still in use in the United States. Now, the European Court of Justice abolished all that. The European Court of Justice told us that Article 17 of the Designs Directive, which says that it's up to the member states to determine the extent of copyright protection for designs, is not valid anymore, has been derogated by the unified European concept of work, which now means that there's probably a larger degree of overlap. The Court of Justice tells us in the COFEMEL case that there shouldn't be a total overlap, but that it should only apply in some situations. But unfortunately, the Court of Justice doesn't tell us which situations these are. Now, we have seen a couple of new neighboring rights, and this is where I actually do say a few words about the topic that has been allocated to me. The sui generis protection of databases, press publishers' rights. I will come to a critique in a moment. These are probably the types of expansion which are most problematic and with which we might disagree the most. Of course, the question is whether this might go on, whether new neighboring rights might be created in the future. Data were already addressed on a couple of occasions today. As far as I understand it, the idea to create a new intellectual property right in industrial data is basically off the European agenda. That had been considered for a while. I think this plan has been given up, rightly so, for a couple of reasons. We don't really need that right. It's almost impossible to define those data. There might be overreach. There might be very difficult problems of overlap. So I think this has been given up. Recent legislation rather goes into the direction of granting access to data. The Digital Markets Act is an example in point, and of course the plans for a Data Act as well. So everyone who said in the discussion this morning, well, access is the bigger problem than compared to protection, that is also seems to be very much the trend. Although it should be said that most industrial data would probably be protected as trade secrets anyway. AI-generated works, the other question, should there be a new neighboring right for AI-generated works, given that purely AI creations in copyright law would not be protected? Actually, I think Bill Cornish said once in his textbook, with respect to computer-generated works, the owner is always a he or she, but never an it, which is true for copyright law, which begs the question, should there be a new neighboring right? Well, so far there are no detailed plans, and I would be very skeptical. Scope expansion, a couple of legislative ones, early legislative ones, public lending right, droit de suite. But of course, the most intriguing one, already addressed by Annette, is that the Court of Justice has basically harmonized secondary liability in copyright law judicially. By extending the concept of copyright infringement, by extending the concept of communication to the public to secondary uses, such as hyperlinking, but also the operation of a platform, very, very clearly in the YouTube case. Finally, term extension, copyright from 50 years to 70 years after the death of the author, and more recently, performers and phonogram producers' rights from 50 to 70 years. Trademark law. Well, in trademark law, the old regime has been exchanged for an entirely new European regime consisting of the regulation and consisting of the directive. And of course, there has been subject matter expansion, all shaped in three-dimensional marks, but also many other types of novel trademarks, and scope expansion from a right that was basically a passing off type right against confusion to double identity, to dilution and misappropriation. And there was an extension of trademark law through the back door of unfair competition law, namely the Directive on Comparative Advertising, which doesn't address trademark law as such, but which affects trademark law, as the European Court of Justice told us in the L'Oréal case. Robin is not here anymore, unfortunately, otherwise there would be someone who really doesn't like the L'Oréal case. Well, the Court of Justice told us in the L'Oréal case that actually the use of a trademark which is at odds with the Comparative Advertising Directive can qualify as trademark infringement. Finally, the allied rights, as Bill called them. Designs, a little bit like trademark law, the old regime has been supplanted by or has been exchanged for an entirely new one, the design approach, as it was called. And this design approach has perhaps several features which were new in at least some member states. Certainly two of them are the introduction of a new unregistered design right. Unregistered design rights existed before in British law, but in most continental European jurisdictions they didn't exist. The term in designs is a bit different. In copyright law, we've seen this upward harmonization to the highest possible standard that existed in the European Union. That wasn't the case in design law. In design law, the term of up to 25 years is a compromise between a wide range of different terms that existed before that in the European Union. Unfair competition. Now you see this rather intriguing split planet here. Well, this planet is split because in unfair competition law we can distinguish between the protection of traders, that is the area that traditionally in English law would be referred to as economic torts, passing off, injurious falsehood and the like, and consumer protection against unfair competition. Now, the protection of traders has largely been unaffected by European harmonization. There is no harmonization of unregistered trademarks / passing off so far. But the consumer protection part, misleading practices, aggressive practices, has been fully harmonized by means of the Unfair Commercial Practices Directive. And difficult to say whether that's an expansion, and certainly it's not intellectual property law at all, so difficult to speak about an expansion. But what is interesting, methodologically speaking, is that in that area we've seen a trend from broad notions of fairness, like European law used to be governed by one single general clause which said unfair competition is prohibited, to ever more detailed catalogues of unfair acts. Actually, the new round is coming. The the changes, the proposed amendments to the directive which concern greenwashing will bring us a long additional list of detailed provisions. Finally, trade secrets, again, already discussed today, a new EU law regime. Speaking from a German perspective, this has really exchanged the old regime for a more nuanced protection regime, probably not with respect to English law of protection of confidential information, but certainly in German law, for instance, reverse engineering used to be illegal. So we did get a couple of additional exceptions here. But as Tanya already pointed out this morning, what I would like to call moderately IP-ish remedies, that is, remedies which were modeled on intellectual property law, which stress proportionality a bit more. Now, where does this leave us? What did Bill Cornish think about the expansion of intellectual property, and particularly about the EU law expansion of intellectual property? Now, unfortunately, I haven't seen Annette's draft before when I prepared my own presentation, because she basically talked about that, and she gave us many quotations from Bill's speech back then at the Max Planck Symposium, from which it became abundantly clear what the answer was. Did Bill like expansion? The answer is no. Now, I also collected a couple of quotations, this time from the third edition of his work, which was the last, or he may have been, the fourth edition may have been the last one which he wrote without co-authors. And so I chose this older edition, and just more or less a random collection on comments on some of these expansions. First of all, copyright protection for industrial designs. Now, this comment, of course, relates to the 1968 UK Act and the problems with industrial design in the UK. But I nevertheless chose it because it seems to be very appropriate also for the present situation after CIPIL, where Bill wrote, the 1960 Act ushered in a merry litigious bonanza. And that is what we're seeing in some member states at the moment. We certainly see it in Germany, Rubik's Cube, the Birkenstock sandals, copyright protection is being claimed for all of them. There's an interesting English case about a great device called the water rower, where also copyright protection has been claimed for the water rower. And we see that after CIPIL in some member states, creators of iconic designs expect a new spring for their creations. On photographs in general, but with a particular emphasis on press photographs, some form of related rights for these latter productions may be introduced, and with it, much complicated law to distinguish between the various categories. Eventually, Brussels may impose such orthodoxy in the name of approximation of laws. Well, the press publisher's right is a little bit like that. Bill was commenting on photographs, but press photographs are, of course, covered by the press publisher's right. On the extent of trademark protection, courts everywhere would do well to recall the need in building a European community system of registration to adopt a moderate approach to protection and intervene only where the plaintiff faces substantial rather than fancied injury. On comparative advertising, much of continental Europe views on comparative advertising from a protectionist perspective, which has sometimes held little appeal in Britain. Bit of understatement here, sometimes held little appeal in Britain. On the unregistered community design right, this plan is destined to roll in a fog of new uncertainties. Now, the problem when I was allocated this topic is we basically all agree. Most of us are also skeptical, perhaps not about every single bit. Annette, as one of the mothers of the design system, might not really agree with Bill's last comment, but generally we think that the overextension of intellectual property is a development to be very critical of. So what should I do here? Preaching to the converted? I sat at my desk and I didn't really know how to take it from here. And then my way out was this one. I thought that I might offer you a sketchy typology of European harmonization / expansion of intellectual property and try to come up with 4 categories of expansion of intellectual property law, which might allow us to criticize these developments in a perhaps more nuanced way. And since it's late in the day, I should also be a little bit entertaining, and so I called this typology the good, the bad, and the ugly. Now, first one, type 1, upwards harmonization to the greatest common denominator. And that is certainly what we've seen in some fields. The prime example is probably the extension of copyright of the copyright term to 70 years after the death of the author. The situation was that, of course, the free movement of goods was hampered by the differences between terms. There were a couple of cases where you couldn't import records, for example, into Germany because Germany had the long term and most, if not all, other European countries had not. They had 50 years after the death of the author. So what did the Commission do, and what did the European Union do? Well, they extended the term to 70 years because Germany had already had it. That is what I mean by upward harmonization to the greatest common denominator. I will comment on that in a moment. But first of all, let me give you some more examples. Copyright protection for works of applied art, I'm not so quite sure about that, because of course that's not a legislative development. That is something the Court of Justice has done. But even there, the highest common denominator is French law, which allows full cumulation after the unity of arts doctrine. And so this is certainly also some sort of upward harmonization. The extension of trademark protection, well, that is more complex because a new European model was set in place, which came in place of the others. But nevertheless, there are some instances where this extended protection was already there in some European member states, most notably in Benelux law. And also the enforcement directive, particularly the first draft, which was particularly bad, because that really looked like a combination of the strictest possible remedies that the Commission could find anywhere in Europe, put them together in one directive. The eventual enforcement directive that we have is still strict, is still an upward harmonization, but it's more nuanced than the original one. Now, what to think of this? Well, one can understand why the Commission does this, particularly the very first instance, because that way you avoid tricky constitutional law issues. Coming back to our general theme of property, well, if copyright law is property, then limiting copyright protection from 70 to 50 years post-mortem auctores might be expropriation. And actually, the German Federal Supreme Court had decided in another case that this might be expropriation. So you avoid these constitutional law issues. I added the word surmountable here. I think you can overcome those constitutional issues by intertemporal law, and actually there is also an example in German law for that, because performing artists before the German Act of 1965 had received full copyright protection, and when the Act of 1965 came, they only got a neighboring right with a shorter term, and the constitutional issues could be overcome by some intertemporal provisions. But nevertheless, that is probably the reason for this type of harmonization. The good, the bad, and the ugly. Bad, because normally you should look for a nuanced approach and you shouldn't just look for the maximum. However, I would argue that this approach is likely to become less frequent due to the present state of harmonization. Those were the early days when European jurisdictions still differed very much. There are not so many areas left in European intellectual property law where this is likely to happen. Second type, inclusive harmonization, and by inclusive I mean extending intellectual property law to unharmonized areas which have turned out to be very difficult to harmonize. Let me give you some examples. Protection of well-known trademarks. Well, protection of well-known trademarks used to be there even before the harmonization in many jurisdictions, but quite often it was done by means of unfair competition law. Again, German law is an example. We had the very classical notion of trademark protection against confusion only, but then there was unfair competition law out there which extended trademark protection under very uncertain criteria. Now, if you incorporate this part into intellectual property law, you can harmonize it, you get rid of different European solutions. Perhaps, at least in some states, the criteria become a little bit clearer than they used to be before. Protection of unregistered designs is another example, because again, formerly, the copying of designs was largely fought by means or on the basis of unfair competition law, and the unregistered design right partly intended to put something else in place, namely a rather well-defined intellectual property right for just 3 years and not for longer. Hasn't really worked out, because in many member states the courts have nevertheless continued applying unfair competition law. And finally, the broad concept of communication to the public. The Court of Justice hasn't been so outspoken, but Advocate General Spooner was very outspoken in one of his opinions, and he said, well, the harmonization project of communication to the public remains a harmonization project which doesn't really work if we don't take secondary liability into account. Well, Bill Cornish, against all types of expansions, but nevertheless, in one of the text bits that you cited, Annette, was of the same opinion, because it's really platform liability that we somehow need to get to grips with if we want to come up with a common European copyright internet regime. So what the Court of Justice basically did by extending its notion of communication to the public was harmonizing the very, very different models of secondary liability, which are so different because they are basically tort law concepts, and tort law has never been harmonized in the European Union, and it will be very difficult to harmonize tort law in the European Union. Now, where should this be placed on the range of good, bad, and ugly? Well, harmonization of the area itself may not be feasible. This happened in unfair competition law. Unfair competition law against imitation has turned out not to be harmonizable, as it were. And definitely that's the case with secondary liability, which would probably be almost impossible to harmonize in general. Now, you might object that harmonization is not an end in itself, and that we should rather leave the national systems in place rather than have an imbalanced or overreaching intellectual property model. However, you might say that if you think that the European Union is a good thing, if you don't like Brexit, and if you think that a European Union should work, in particular in the area of economic law, then in some areas harmonization might be necessary. And it might be necessary to avoid circumvention, and it might allow more honest and open solutions. So, for instance, trademark protection against misappropriation, against taking unfair advantage. I guess that many of you are very critical about that, and it's easy to be critical about that. But on the other hand, you get all sorts of bypasses like post-sale confusion and what have you, if judges feel that something unfair has gone on. If there is this provision against taking unfair advantage, it allows open and honest balancing of interests. And in a way, that's also why I don't see the Court of Justice's YouTube judgment so critical. Because in the YouTube judgment, the Court of Justice comes up with clear duties of care that providers have to meet. And if we get there, if we come up with a clear catalogue of duties of care, that might be a more honest solution than allowing all murky national doctrines to continue. Of course, part of this problem exists because unfair competition law has only partly been harmonized, and a very interesting question is whether this missing part of unfair competition law, the protection of traders, will be harmonized at some stage. I think some areas could be harmonized. Actually, in the area of passing off, there are only minor differences between the member states, even if we call that differently. If the French would apply their general clause and call it the category of confusion developed by the courts under the general clause, even if the Germans call it unregistered trademarks, and the English, well, not there in the harmonization project anymore, call it the Irish. The Irish call it passing off. This area might be ripe for some sort of harmonization, and it might take the pressure off intellectual property law. Type 3, creation of entirely new EU law regimes, which are partly broader, partly narrower. Design law is probably an example in point, and trade secrecy protection definitely is. Trade secrecy protection compared to what pre-existed is probably in some ways broader. Certainly compared to former German law, the remedies are stricter than they used to be. But in other areas, particularly when it comes to exceptions for whistleblowing, for free speech, for reverse engineering, there is more limited protection that has been granted here. And this is probably the one category that I tend to see as good, because this might be a more nuanced way forward, despite all criticisms in detail. We can talk about the Trade Secrets Directive for a long time, and I'm not entirely happy with it. But nevertheless, the approach of coming up with a nuanced, balanced European approach might be a good one. This is the one point where I am moderately optimistic, because one tendency that we tend to see in recent legislation, but also in recent case law, is that there seems to be a trend towards more nuanced solutions. And one reason might be that the Commission and the Court of Justice might be more likely to give more weight to countervailing rights once they have secured control. When the Court of Justice still tried to make sure that it's a European approach to copyright law rather than national approaches, the Court of Justice was still very strict and said that defenses have to be construed very narrowly. Now that the Court of Justice has secured control and that really copyright law is generally regarded as harmonized, we see a tendency that the Court of Justice is attaching more weight to countervailing rights. The triplet of cases, Funke Medien, Spiegel Online, Pelham, decided in 2019 is a nice example of where the Court of Justice did not interpret copyright exceptions narrowly anymore, but tried to give effect to the constitutional rights that inform these exceptions, and that might be a tendency that we might be seeing on the European level. But let's not be too optimistic, and let's come to the ugly, namely expansions based on what I call contestable social or economic justifications. In the first draft, it was called expansions based on lobbying. Now, many of these expansions are based on lobbying, but these ones are probably particularly bad. First of all, the sui generis protection of databases. Now, this is what I would call an expansion based on contestable economic justifications. The idea was to create incentives for the European database industry. However, it was a bad idea to create incentives by an ill-defined right with many open notions and a potentially overreaching right. Meanwhile, all evaluations have shown that this idea of creating incentives to the European database industry, this hasn't really worked. There are as many databases, or the trend is not different from before we received that right. Of course, the European Court of Justice limited that right in some important respects in the sports decisions, BHB, and so on. Term extension of the sound recording rights. Now, I'm only referring to the sound recording right here. I do have some sympathy for performing artists such as Sir Cliff Richard, who was one of the lobbyists for this extension, but I have little sympathy for sound recorders for whom it's just an unfair competition right, it's just an economic right, and they sort of sailed in the wake of these of the extension for performers. The press publishers' right, an awful piece of lobbying, first in Germany and in Spain. In Germany, it was quite clear it was Axel Springer, the biggest publishing house in the newspaper area, which lobbied heavily for this right. I don't know a single copyright lawyer, from conservative and pro-protection to progressive and skeptical of protection, who would have liked this right. There are lots of articles were written in Germany against the German version of this right. Nobody liked it, but it came anyway. And the anti-value gap legislation in Article 17 might also be an example in point here. So this is partly justified with contestable economic assumptions, like the database right that I mentioned, also the term extension for sound recording rights, which was partly economically motivated, but the economic evidence, for which Bill also called, was a very slim and not very reliable economic evidence, and it reminded me very much on von Hayek's criticism of a pretense of knowledge. You tend to know certain things that you can't know in the market. There has been a lot of academic resistance against all of these, particularly against the press publishers' right, but this academic resistance has turned out to be mostly fruitless, and this leads me to put this category into the ugly category. Nevertheless, we shouldn't stop resisting these strange introductions. So where does this leave us? This perhaps shows us that if we agree that harmonization in the European Union is not necessarily a bad thing, there are different kinds of harmonization. Some of them entail replacing old models by new ones. Some of them entail some sort of expansion. Some overdo things. And I think it's very difficult to come up with a general criticism. But nevertheless, apart from the type 3 case that I mentioned here, you will have heard that I also chime in with the general skepticism. That was also the Cornish skepticism. And on that note, I would like to end here with my conclusion. You all know this beautiful mosaic in Pompeii, which shows a dog and the inscription Cave Canem, beware of the dog. And I would like to modify that into Cave Expansionem. Thank you very much for your attention.